Hello, everyone. Welcome to the second episode of the Cybersecurity and Data Privacy series. My name is Priscilla Chataika, and I'll be your moderator today. Our panelists today are Alex Sharp of Sharp LLC. Alex, would you like to introduce yourself?
Sure. Alex Sharp. Uh, I'm the practitioner on the panel. Been in this space for 35 years. Started out my career working for the US federal government, went on to working at some of the large consulting firms where I built and led some practices, did a couple of startups, also services firms, and now I'm a solo practitioner. Uh, Really, the value I bring to the table is not only having a deep expertise in privacy, but also cybersecurity and digital business helps to take the fragments and optimize the whole.
We also have Gabriel Bueller of Bueller Law. Gabriel, would you like to introduce yourself?
Yeah, thanks for having me. So I work in-house for a technology company. It's also a data broker in a handful of states here in the United States. Um, and then my solo practice, Bueller Law PLLC, specializes and focuses on business law, privacy, and technology law. So.
And we also have Julian Schneider of the University of California. Julian, would you like to introduce yourself?
Yes, of course. Thanks for having me. So I'm a dual qualified attorney in Germany and the United States, California more specifically. As you can hear, I'm originally from Germany. My firm mainly does international compliance and questions of complex international data transfers and privacy programs. So that's what I will mainly talk about here. And I also teach AI law and data privacy law at the University of California in San Francisco.
Thanks. And like I mentioned, my name is Priscilla Chataika, and I'm from Daily DAC or Financial Poise. Before we get started, just a quick disclaimer on slide 5. The material in this webinar is for informational purposes only. It should not be considered legal, financial, or other professional advice. If you'd like to find out more about our panelists and get their contact information, please refer to slides 46 to slide 48. On slides 7 to 8, we've also provided a summary description of this webinar and this series. And we'll be referring to the General Data Protection Regulation, in short, to the GDPR. To get us started, Julian, would you mind giving us a bit of an introduction on the GDPR?
Yes, thank you. So GDPR stands for General Data Protection Regulation, as mentioned before, and the name already says a lot. It's a very comprehensive legal framework of the European Union that was enacted in 2016 and went into force in 2018. It essentially is a very comprehensive legislation on data privacy that has three main purposes. First, when we talk about the European Union, it's always about markets. It's always about moving people, moving goods, in this case, moving personal information from one country to another. Second, we were talking about protection of consumer data, of course. And third, the GDPR wants to regulate emerging and new technologies, for example, social networks. As such, the General Data Protection Regulation at least aims to be an easy framework that facilitates international data privacy within and even outside the European Union.
And Alex, please, would you explain how the GDPR would apply to American businesses and the type of clients you work with?
Sure. It actually applies in a couple different ways. The most direct is if you have, if you're an entity and you're doing business in the EU, it it applies. It's just that simple. If you have information related to individuals in within the EU, you are subject to the GDPR. But the other way it applies is indirectly. The GDPR has become the foundational privacy standard globally. So you see the terms and concepts that are embodied in the GDPR really finding their way into a lot of other places. And a lot of organizations, a lot of countries, jurisdictions will actually advertise that they are based on the GDPR and will produce kind of like cheat sheets that say where they differ, right? So it's very foundational. And then there's another way it tends to come in, which doesn't often get talked about, because the GDPR is so foundational and sets a lot of concepts and terminology. We see those same concepts and the terminology being used in other places and being used as a foundation. One of the areas that I see that happening pretty much daily at this point is around AI. Um, it's so while you don't think of GDPR there, a lot of the stuff that came out of the GDPR has found its way, its tentacles into a lot of other areas. So it truly is foundational.
And as Alex had mentioned, it's influenced a bunch of different countries that have introduced their own laws, such as Brazil, Australia, Canada, Japan. And so being compliant with GDPR doesn't mean that you're compliant with all the laws internationally and in all states. Gabriel, would you mind explaining how, for instance, a company would also need to comply with laws in Washington?
Yeah. So first and foremost, navigating GDPR applicability to a Washington-based company in and of itself can sometimes be a little challenging and complex. As Alex mentioned, if you're offering goods or services there, if you're monitoring behavior on EU residents, or if you have an establishment, or even if you're contracting with an EU-based entity, then certainly the GDPR will apply. And that would likely be the same case across all of those other jurisdictions that you just mentioned. But it depends heavily on the types of data that's being collected and processed, where those consumers are located, and what the data is being used for. Now, as far as I've seen in many cases, Washington businesses will typically hold the posture that they act solely as a processor under GDPR, which means there are slightly different obligations than if you were a controller under GDPR. But nonetheless, I think what can often be the most surprising hurdle for Washington businesses, and not just for GDPR, but for all of these compliance frameworks, is just the sheer volume of documentation required by a business in order to demonstrate compliance, whether as a controller or a processor. Between all the various policies that have to be publicly facing, your security certifications, internal audits, and due diligence forms, things like data privacy impact assessments and transfer impact assessments, as well as all the new added contractual layers that are there that weren't there 10 years ago, that make relatively simple and straightforward relationships, business relationships, now much more complex. That tends to be one of the most challenging things for Washington businesses as it relates to GDPR. But even stepping away a little bit from GDPR, you also have My Health, My Data. So it's not necessarily a broad sweeping privacy law similar to GDPR, but for Washington businesses, it's significantly expanded HIPAA. And so they have to set up their privacy framework and posture in order to account for that.
Thank you. So like as Gabriel mentioned that a lot of different states are introducing their own privacy laws. And as of 2025, 20 states have introduced their own consumer privacy laws. So it's more of a patchwork system than a comprehensive system like the GDPR. And about 144 countries have their own privacy laws. With that in mind, Alex, do you think this makes compliance easier or does that make compliance more difficult?
Yes. So let's dig into that. The US is actually more complicated than that 2020 leads you to believe. And let me explain that a bit. For a number of reasons, there's actually 54, at least 54 jurisdictions in the United States that can write their own privacy laws, right? You sit there and go, we only got 50 states. What's going on? Well, you got DC, you got the possessions, and it turns out that in the indigenous people, the tribes, can actually write their own privacy laws depending on how they are incorporated, right? So it's even more complicated. And then to make it even more complicated is we often forget there's data breach laws. So each state also has a series of data breach laws. So if you have a breach, you not only have to worry about your privacy and whatever cyber reporting you have, but you have this data breach thing. And I think the last count, California had the most, and that was 25 data breach up to 25 data breach laws. So it gets even more complicated. So let me dig into that a bit. The number one thing, and I had a laugh when Gabriel said it, is truly the most challenging or the most effort on this is the documentation and the paperwork. The second part, the second most challenging, is getting people over the hurdle to understand what these 300 pages really say, right? Because with any law, it's usually very long and it takes a while to find out all the details. So when you start getting into it, you find that all these different state laws are actually more alike than they are different. So you can come up with tables, they're commercially available, that will actually show you what the deltas are between each, and you have to do your research to dig into the nuances. But when you start looking at that, it's really not as overwhelming as you would initially think. So a lot of this is education and awareness, and having people like Julian and Gabriel, who do this every day, walk you through those deltas, is it's well worth your investment. It's that simple.
And
Gabriel, would you like to maybe explain the approach or strategies that companies would take?
yeah, absolutely. It's a global approach. I've always advocated that you adopt a risk-based kind of one policy, many controls approach. So in other words, you keep a single enterprise privacy program. All of your governance, your data inventories, your DPIA engines and everything that you're building on the front end, you match that up against kind of the highest watermark benchmark of GDPR. Right now, as far as we've been able to see, that's the gold standard. And then from there, you layer in these jurisdictional add-ons. As Alex was mentioning, there are many commercially available tables where you can see the minor changes and deviations, whether it's state to state or country to country, where you might add in things to your privacy policy. Some of this will become publicly facing. Some of it is going to be for internal purposes. But you might have your overarching privacy program, and then you have your My Health, My Data addendum. You have a CPRA addendum. You have an LGBT addendum. Things that are specific to those markets and those jurisdictions. But overall, you're setting your policy and your approach globally to the highest possible standard. It makes it a lot easier to ensure that you're compliant across all of the various different jurisdictions versus a patchwork compliance where, oh, this state came out with this new privacy law. We're going to build from the ground up, right? This country came out with a new privacy law and we might have consumers in that market. We're going to build from the ground up. If you set your policy to the highest possible mark, the rest is just layering in jurisdictional deviations and such. And then more generally speaking, kind of reliance on data minimization and retention discipline. In essentially every regime, data minimization is a huge part of it. Being able to justify the purpose for the collection or the processing, to minimize the collection, and to really enforce deletion internally. You'll end up clearing most regimes. And then I think Julian is going to end up talking about international transfers, but that's a whole separate part that's widely, but it's especially important when you talk about Washington businesses that might be doing business with EU-based companies, having a really, really solid framework in which you're managing your international transfers.
Thanks,
So
Gabriel.
can I highlight something that Gabriel just mentioned?
Go ahead, Alex.
Data minimization. Bold it, put in italics, underline it, neon arrows. The less data you have and the more deliberate you are about your data, the less headaches you have, or the fewer headaches you have, and the less trouble you can get into. And one of the reasons I bring this up is right now with the advent of AI, with AI suddenly becoming popular the way it has in the past few years, there is a tendency to over collect data because AI works by finding new relationships, new trends, they get new outcome and new value from data. So there's a tendency to over collect. And the moment you over collect, you run the risk of infringing on these privacy issues. You run into other things. You are required to do protection. You're required to retain this information for basically the useful life plus 7 years. So if you're a mortgage company, you can be stuck with this for 37 years, right? So data minimization is incredibly important to the success of your program. And I would work with your folks to ensure that they, to resist the temptation to over collect.
Thanks for the advice, Alex. Now, before we dive deeper into the GDPR, we also need to look at the history of the EU's data protection framework. Julian, please give us a brief history of the EU's early data protection framework.
Sure. Gabriel just mentioned the issue of patchwork legislation, and I think it's always important to consider that the European Union is different from the United States. From an American perspective, it always looks quite similar. You have like the member states, you have the states, you have the federal government, you have the European Union government, but that's not entirely true. The European Union is based on its member states. So you have member state legislation that becomes European Union legislation at some point. And in this case, the first privacy law worldwide was enacted in a German state in 1970. No worries, 55 years of history. I'm going to keep it brief. But 55 years ago, one German state enacted the first privacy law in the world. 10 years later, the OECD guidelines were published, and those guidelines are actually quite similar to privacy laws we know today. They, for example, include most of individual subject privacy rights that are nowadays included in the GDPR. That was still back in 1980. And as you all know, in 1990, something important happened in global politics, the downfall of the Soviet Union, of East Germany. And in that process, it was disclosed that you had massive privacy violations in those countries. So you had secret police, you had lists of opponents of the government. And the European Union thought, well, we have to do something about it. We have to set a sign here. And this sign was set in 1995 by the European Data Protection Directive. I will get to the differences between a directive and a regulation. That's important too. But basically, the Data Protection Directive was the first comprehensive European legal framework on data privacy. And basically, it said that data privacy is not a national topic. It's not just a member state topic, but it's a topic for the entire European Union. And I think that's always important to consider. You always have this political background. You always have the rise of totalitarianism, and you have data privacy as a human right, as a foundational right of human beings. That's always a bit difficult to explain that from an American perspective, but I think that's enshrined in the constitutional documents of the European Union and its member states. So the role of data privacy for the individual was something that was created by this data protection directive within the European Union 30 years ago.
Okay. And would you like to explain maybe a little bit about the weaknesses of the directive that led to the GDPR?
Yes, of course. So as mentioned, regulations and directives are different from each other. Regulations like the GDPR apply directly and immediately. They don't need any legal implementation. If you have a directive, on the other hand, you need member state implementation. That means you must make the directive, the content of the directive, part of your national member state law. And that leads to some differences. Basically, a directive is kind of a mandatory guideline. So you have to follow that guideline, but it doesn't say how you have to do it. So we created kind of a fragmented member state law landscape. You had national data privacy laws in Germany, Italy, Austria. They all were different from each other. It's very similar to the current state law landscape within the United States, for example. And it was not great as a situation. In theory, the data privacy directive should make it easier to transfer data between the member states. As mentioned before, the European Union is always about markets. But it didn't. In fact, it didn't, because you had to follow different regulations, different laws, you had different regulators. You still have different regulators, but it's another issue we will talk about. And That's one weakness. So the fragmented landscape is one main weakness we had. The other weakness was, if you think back to 1995, which I can hardly do, by the way, I was 6 years old. So the internet, as we know it, didn't really exist, right? We didn't have any social networks. We did not have big data. Alex and Gabriel just mentioned data minimization. We didn't even have data maximization at that point, right? So nobody thought about collecting data just because they could. So the directive could not address big data because it didn't exist, at least not in the current form. I think that was the other big weakness, and the directive actually did not apply to companies outside of the European Union. So if you talk about Microsoft, if you talk about Google, which didn't exist either, it was impossible for them to be subject to the European data privacy legislation. So essentially, you could say the privacy directive was a European Union law for the European Union, while the GDPR is the European Union law for the world.
Thanks, Julian. And under the GDPR, we also need to understand the key players. And at the center are the data subjects. And we also have data controllers and we have data processors. Alex, please could you explain what a data subject is and what would constitute personal information?
Yes. These are foundational concepts to your point on GDPR. So what it all, and by the way, when we talk about all the differences in the privacy laws, there tends to be a core set of data elements that are considered personal information, but you have to check every jurisdiction, every law that you're dealing with to look for subtleties. Two things that I'm seeing a lot of these days is we're starting to see a lot of states and countries modifying their privacy or creating additional laws that deal with things like biometrics. And that's including different dimensions. And it also has some subtleties around the way it's being collected. So I highly encourage you that I'll give you my cheat sheet aggregated list, but on any jurisdiction you deal with, this is one of the things you want to dig into, right? Because this is an area that changes and gets modified. I don't want to say fairly often, but it does get often, it gets modified with trends like AI and biometrics. So on the short, and let me explain what a data subject is. Working definition of a data subject, it's a natural person that owns the data. One way to look at the difference between compliance and privacy is if you think of your data set as a set of columns that are the the elements, and you think of the rows as the data subjects, the individuals that own them. Privacy deals with the rows, compliance deals with the columns. So you're dealing with like cybersecurity regulations or AI regulations, it deals up and down the columns, where in privacy, you're worried about the rows because the data subjects are the ones that the information is about, and they get to dictate who can have it and how it's dealt with, right? And the authority and the details of that are what's specified in the laws. So think of the data subject as the individual, the natural person, the human that owns those data elements, and it relies on you to properly handle them in accordance with their wishes. So think of it that way. In terms of data elements, the basic set, pretty much everybody in the call could name most, if not all of these, just thinking about it. Name, address, city, zip code, some people call it a postal code, country, telephone number, age or date of birth, gender, race, and believe it or not, cookies. Cookies are the thing that everybody forgets about, and they also happen to be one of the areas that get people and organizations into trouble. Not so much anymore for really two reasons. It's just kind of nature of the beast. When people get in trouble for not properly handling cookies, everybody else starts to get in front of that. And then the other thing is all the product vendors start building those facilities in. you've probably noticed over the past couple of years, whenever you log into a new site or you go to download something, this thing pops up and asks you, what do you want to do about the cookies? That's the reason.
Got it. And Gabriel, please may you explain the difference between a data processor and a data controller?
Mm-hmm. Yeah, so under GDPR, the controller essentially decides what, why, and how data is processed. So, what data, why it's processed, how it's processed. And in that role, a controller carries substantially more obligations under GDPR than the processor or any processor that they engage as it relates to the handling of the personal information, but then also notice and consent at time of collection, registration with the appropriate member state authority. A processor, on the other hand, acts on behalf of the controller, right? And they're following very strict documented instructions. And because that's their role, they don't have the same obligations that a controller has. If we look at comparable roles in like California, you have business and service provider, right? So the processor does have additional obligations, though, in assisting with GDPR compliance, whether that's through audits or regulatory action that they need to be able to provide information for or to the controller, but also ensuring that there is no sub-processing without approval if you're the processor. Those are some of the table stakes. And between a controller and a processor, there always needs to be some form of a data protection agreement or data protection addendum. It basically goes by a DPA that clearly sets forth the roles of the party. So we're a controller, you're a processor. What data will be processed very specifically, the purpose of the processing, additional clauses that would be related to like cross-border transactions or onward transfers to other sub-processors, as well as identifying, as of that date, any sub-processors. That's why I was saying earlier that this is one of those things that Washington businesses probably didn't have to deal with a decade ago. They definitely didn't have to deal with it a decade ago. And now they have these long bloated documents just to make sure that data is processed and handled appropriately. And it's not always that cut and dry. It's not always just controller processor. In really complex ecosystems, when you get into ad tech or cloud environments, you can have kind of a joint or a mixed role. You might have joint controllers, or one company is a controller, the other is an independent controller, but also acts as a processor. It really depends on the processing activity when you're dealing with large data sets. So you establish these agreements per data flow and not just based on the company. It would be inappropriate just to have a boilerplate DPA that you provide to every single processor and you never work with the actual terms of the processing. That's just not how data works. So that's kind of controller and processor. And then obviously in California, as I mentioned, it's more of the business and service provider. For the most part, though, the obligations do tend to mirror GDPR. There are some deviations, though.
Thanks, Gabriel.
Mm-hmm.
And as Alex mentioned, slide 20 highlights a major shift under the GDPR, and it's expanded its scope beyond just businesses operating in the EU. So if you have businesses that are not operating in the EU, and as long as they are dealing with data of citizens or residents in the EU, you still have to comply with the GDPR. In terms of Article 5, Julian, would you mind explaining what Article 5 of the GDPR entails?
Yes, I mentioned those OECD principles before, and those GDPR requirements, those key principles basically mirror the OECD guidelines or principles. So we have 7 foundational approaches of the GDPR that basically lay a foundation for specific regulations on obligations you have as a controller, as a processor, or rights you have as a data subject. Lawfulness, point 1, for example, is that you basically need a justification to process any kind of personal data. So you cannot process any data without justification, and justification means a legal reason under the GDPR. So compliance with the GDPR serves the principle of lawfulness. Data minimization, we mentioned that before, basically means that you store only the data you need. So that's one key principle, I would say. That's basically what data privacy and data protection legislation in the European Union is built on. You only store what you need. Another key principle is accountability. So when I say you, whom do I mean? Whom am I talking about? Is it the controller? Is it the processor? We need to have clear roles, as Gabriel explained. We need to make clear who takes which role. You don't do that contractually, by the way, but you determine the role you have by law. So you cannot change your role just by contract. That doesn't work. Accountability means that it's always clear to the customer, to the data subject, who is in charge. Who is in charge of my data? Whom could I ask if I have any questions? And if I want to make use of my rights under the GDPR, who could I, well, sue if I have to, but whom could I, against whom could I take action on my own behalf? So those principles lie at the heart of the GDPR, you could say. And everything else in the GDPR you should know, but if you comply with those principles, if you try to comply with those principles, that's a huge step for any privacy compliance program.
Thanks, Julian. And would you mind explaining Article 6 of the GDPR?
Yes, as mentioned before, or no, I wouldn't mind. As mentioned before, we have the requirement of lawfulness, the principle of lawfulness, and Article 6 specifies that requirement and gives you a different legal basis for data processing. The main basis, at least in theory, is consent. So in theory, you always want to have consent by your data subject. In practice, that doesn't work that well because consent can be withdrawn or consent can be invalid. For example, it cannot be freely given. That's a huge issue with employees, for example. So you need other lawful bases, typically. Most businesses, most of my clients want other legal bases. Contracts are great, for example. Contract means if someone buys something from you and you have to send that item to the customer, of course you can use the address. Of course you can use the name, otherwise you could not fulfill your contract, and you don't want to have separate consent that could be withdrawn. It just wouldn't make sense, right? The favorite lawful base for many clients is legitimate interest because it sounds great. It sounds great, but for an interest to be legitimate, it must be lawful first, which can be an issue in and by itself, to be honest. And second, it needs to be something that actually makes sense for a regulator. And third, it says the processing must be necessary, not just helpful, not just reasonable, necessary. You can't fulfill that legitimate interest without processing the data in question. So if we circle back to data minimization, you always have to ask yourself, what do I need to reach that legitimate interest, to further that legitimate interest? So as you can see, those principles and Article 6, the lawfulness legal basis, are connected, interconnected, and intertwined. And you cannot think lawful base without data privacy principles. And Article 6 is all about lawful base. Article 6 is all about the principle of lawfulness and transparency.
Thanks, Julian. Gabriel, would you mind expanding a bit more on what would constitute valid consent?
Yeah, so Julian briefly mentioned it. Put simply, it's freely given. It's not coerced or procured through some dark pattern that you have with the user interface. It's specific to the types of data that will be collected, used, what purposes it's used for. It's informed, it's unambiguous. And for like Article 9 special category data, it's explicit. And there's no pre-ticked boxes. You're not bundling these consents across a couple of different interactions. And most importantly, it's easy to withdraw. So if you don't have a mechanism on your website or for the data subjects that you're interacting with for them to withdraw consent, it's not legitimate consent, correct? Now, some of the I would say unintentional failures with the consent gathering, because I always believe that companies are trying to abide by it and trying to do well by the consumer. But cookie walls and forced consent is a big issue. Alex touched on it briefly, but for things like non-essential tracking, your cookie banner just pops up and it just says accept, right? Well, in the EU, you have to be able to provide options and preferences, whether it's essential, yes, non-essential, no, accept all, reject non-essential, customized choices, right? You have to provide options and preferences to these data subjects that are accessing your website. Another issue is kind of dark patterns in any sort of UI or any sort of product that you provide to that a consumer can access. And these are user interfaces or designs. They kind of manipulate or trick users into taking actions or providing consent, for instance, that they wouldn't normally provide or actions they wouldn't normally take. So just to accept all, right? Rather than actually providing the preferences to the consumer, you just have a button that says accept all. And even the European Data Protection Board has warned against things like that. Also, other consent mishaps is like kind of vague purposes, right? Buried in your privacy policy. You're like, oh, we might use this data to improve our service, or we might share it with our partners, right? It's very vague. It's hard for the consumer to actually understand what the data is being used for and what's being shared. That wouldn't be considered specific or informed in procuring the consent for that. And then just to, again, put another pin in it, is that equivalent withdrawal control, right? The consumer has to be able to withdraw consent that they've previously given. Otherwise, it's not valid consent.
Thanks, Gabriel. Alex, Julian and Gabriel mentioned it should be easy to give consent and withdraw. What kind of problems does that create for businesses?
I gotta tell you, after Gabriel and Julian just give those tremendous, spot on recommendations, I feel like I shouldn't be saying anything. They really covered the whole gambit. The 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 real issue at the end of the day here is not getting in the way of fulfilling your obligations. Not getting clever. Don't try to be clever about it. In my experience, organizations get in a lot of trouble with these mechanisms because they get lazy, right? Organizations, and I know that sounds critical, but it is. I've seen organizations time and time again, they will spend a lot of time addressing customer acquisition. How do we attract new customers? How do we onboard them? How do we do this? How do we do that? But they spend very little time of how do you let somebody go who wants to go, right? And they get into trouble sometimes because they go, yeah, okay, fine, we'll just do whatever we need to do, right? And they kind of fluff it off. So they accidentally get themselves into trouble. In reality, the mechanisms to withdraw, and like we're talking about here, are really simpler than the ones of onboarding. Because when you're onboarding, you're trying to minimize friction. You're trying not to turn customers away. You really need to think about it. When somebody wants to leave or say no, they've made the decision of what they want to do. So you just don't have to get in their way. You have to facilitate it and stay out of the way, which is actually a simpler process. It's just one we don't want to think about. So I think companies get themselves into their own trouble and they overcomplicate their situations because it's just not the fun part of the gig.
Absolutely. We'll now move on to the rights of the data subjects. Julian, would you please explain what are the rights that all data subjects have?
Yes, of course. So individual data subject rights are a huge topic, obviously. Private right of action is always the biggest topic you have in compliance law for one simple reason. Enforcement agencies, they are notoriously understaffed and overworked, right? But consumers are like the biggest enforcement agency in the world. So if you have data subject rights, if you talk data subject rights, you have to think enforcement. It's basically an enforcement agency here. And at the core of data subject rights under the GDPR stands Article 15, which is the right to access. Right to access means basically that you have a right to know what is stored about you, which personal data any controller or processor uses about you and has about you. And you have the right to actually access the data. So the controller or responsible party must provide the information to you so that you can analyze it, that you can see where it originates from, and that you know what they actually did to your personal information. That's obviously crucial to gain control of that information that floats like around somewhere on the internet. Secondly, I think another important right is the right to be forgotten. So I used to be a press and media litigator back in Germany for some time, and basically First Amendment law, tort law. So if you have an article about you in your newspaper, sometimes you're flattered, sometimes you're not. So there are good and bad articles about you, and the bad ones you want to vanish, usually, which is possible if they report, for example, false information. But back in the days before the GDPR, it was not possible to delete them, let them be deleted just because they were old, like outdated, 20 years old, 30 years old. That was not generally possible. The GDPR has introduced, under the impression of like search engines, Google and everything, the right to be forgotten. The thresholds are still quite high, so it's not that easy to make something vanish, even theoretically. Practically, of course, it's the internet. The internet does not really forget anything, even if it's deleted at its source. So the right to be forgotten, I would say, is a good attempt at solving one of the biggest problems the internet poses, but I have my doubts whether it's actually as useful as it sounds. But still, it's a great right to have, at least in theory. I think the European Union has to expand on it, to build on it, and to think about it a bit in the future. Lastly, I wanted to address the right to data portability. This is a very interesting one because it does not exist in most privacy legislation in most jurisdictions. Probably because most jurisdictions don't understand it, I would say, because I had trouble understanding it initially when the GDPR came out. Basically, the right to data portability means that you can take your data from one service provider to another one. So you don't have to re-enter your data if you, for example, change your email provider, your social media provider, whatever. You don't have to re-enter your data, but it must be given to you by the first provider so that you can give it to the next one, or it can actually be transmitted from one provider to, or one controller in GDPR language to another. So that's a quite rare law and quite rare right in international data privacy law, and I don't really know why. Maybe Gabriel and Alex know. I really don't, but it's a kind of a GDPR exclusive, you could say.
Yeah,
Thanks.
I was
Go
going to
ahead,
say,
Alex.
I actually agree with the issues about the data portability, and we're starting to see it pop up in other places like the CRA and other places. So it's very, very important, and we seem to have forgotten about it. It's when you think about it, it's also very much related to the Schrems 2 issue and the Schrems 2 decision, right? Which is what you're going to talk about, a little more about international transfers. But what always hits me funny about the portability is what people don't realize is portability is at the core of probably the most famous, oldest privacy law that wasn't really intended to be a privacy law, and that's HIPAA. The P in HIPAA is not privacy, it's portability. And it was really designed so data would not get locked into pockets. So it would benefit the consumer where they could share among different medical providers to improve outcomes and use market forces to pressure costs down. So my kind of guess is why portability is bigger in some areas than others is because some jurisdictions are very much focused on the market dynamics and others are not. But that's kind of my 2 cents. It's interesting you bring that up because that's something that's often puzzled me as well.
Thanks, Alex. We've already touched a bit more about principles. Please, may you explain what privacy by design is?
All right, so privacy design is pretty much the theme that we're talking about here. What you do for one makes you better at the other. So privacy by design was actually, believe it or not, first proposed in the 1970s, and then it became a thing in the 90s, and it's subsequently pretty much become embodied, whether overtly or covertly, in pretty much everything we do in privacy. It's 7 principles that basically state these are the things that you can do that horizontally slice across every um, regulation, legislation, guideline, standard in the privacy sector. The one we've talked about the most here is data minimization. All right, so I'm not going to walk through all 7 principles. You could do that, but the idea is if you embody these 7 principles in your policy, your privacy policy, and then you apply them to everything you do in the privacy world, it's going to give you better outcomes at a lower cost, and you're going to have less headaches.
Thanks, Alex. And Gabriel, for tech companies, does this hinder development in a sense?
Well, I don't think it's just privacy that may potentially hinder innovation. I think anytime you're talking to in-house attorneys or CISOs that operate the security teams at these companies, there's always going to be this balance and pushback between the business units and product teams and stuff, and those that are trying to remain compliant and stay above board from a regulatory perspective. I think that there was an early concern that privacy by design could stifle innovation. But all it really means is you're integrating privacy and data protection into the whole life cycle of product systems and services. So it means that you get your legal team involved a little bit early. You get your CISO team involved a little bit early. It means that as you're having sprints for a product feature, relevant parties internally are also aware of it. And it's not just the wild, wild west where product teams are running out there, developing and throwing stuff against the wall. And why it's important is because when they do that, they're handling consumer data. So they might think we have this great business idea and this could generate a lot of traffic and increase revenue, but you're doing all of that with protected consumer information. And so you should have this backing to it. Ultimately, as if you're on the privacy team, so let's say you're building out a privacy program, it's just about communicating to the product teams, marketing teams, HR teams that, listen, we're going to bake Article 25 into our delivery. We're going to add these like privacy acceptance criteria to every step of these feature developments and product developments. That way, we're not running afoul of our own internal policies. But we also know that once it's deployed and it's launched, it's compliant. And we're not going to run up against later risk issues, right? So you have privacy sprints that run parallel to product sprints, where both departments are in the know about what's going on. Another important thing that I think the legal team and the privacy team can provide is just developer enablement. So if consent is an issue, right? Well, as the privacy team, we should be going out there and finding SDKs for consent, finding solutions that maybe we can provide to our product team that they can build into whatever new product that they're developing, and save them that step, save them that work, so that we know once it launches, it's compliant with all consent issues, right? Same thing with data subject access requests, right? We're dealing with all of these privacy related, potentially product issues. Why wouldn't we as the privacy team be proactive in engaging with our product teams? And the way we can do that is just educate and keep them in the loop and keep asking questions. And when we hear about new product development, don't just sit back on your laurels and say, oh, okay, well, it should be all right. We'll wait until we're dealing with some big issue. Get curious and get involved in product development. And sometimes that means doing research on your own product's technology and better understanding it, rather than just saying, oh, I'm on the legal side, I'm just going to sit here and review contracts. You become embedded in the product frameworks and architectures. And lastly, I think from the legal side, measure it. So everything should be measured. All of the things that we just discussed, tying them to OKRs and just making sure that you're measuring what matters to you as a privacy and a legal team. And you're able to demonstrate that to upper management to get them more involved as you're dealing with product conversations.
And speaking of the privacy team, what is a data protection officer and which companies have to appoint one?
So a data protection officer, generally speaking, so they're an independent privacy expert. They advise, they monitor, they typically chair like the data privacy impact assessments, and they liaise, they work directly with data protection authorities from various member states if an issue arises, but especially the one that they're registered within. Importantly, they report to the highest level, and they are to avoid all conflicts with anybody else within the organization. It's very important that they're independent of all these other processes. More specifically, you can find what a DPO does in Articles 37, 38, and 39. And the EDPB has also provided some explanation further. But when you need one, specifically under GDPR, it's if you're a public authority, if your core activities involve regular, systematic, large-scale monitoring of EU residents, or large-scale special category or criminal data processing. So in those instances, specifically in the EU, you have to have a DPO, and they have to be registered. There are also, by the way, other jurisdictions that require a DPO, Brazil, India, and a few others. So it's really about understanding which laws apply to you. And then also taking a step back from that, if we're establishing a global privacy posture, even if you don't have an on-point law that directly applies to you, and you're basically saying, oh yeah, we're compliant with it, but it doesn't technically apply to us, you may still consider engaging a DPO because we live in a global economy. The likelihood is you have a website or you have products that engage with these global consumers. It'll probably come up. And so it might be best to engage a DPO. It doesn't always have to be a full-time on-site person. You can hire out, you can get somebody that does it part-time. It just depends on what your needs are.
Thanks, Gabriel. And Alex mentioned about the complexity of breach laws. Do you have anything else you'd like to add, Alex?
About the complexity of breach laws?
Breach notification laws.
Oh, breach notification. I think we pretty much said it, right? This is the kind of thing. It's actually the solution's simple, but it takes work. First and foremost, this is a very well-known problem. A lot of people have already done the homework. You can get access to databases. You can call people like Julian and Gabriel to help you sort through it, right? So remember, this is a problem that's been solved before. Your specific situation is probably a little different in some ways, but leverage the body of knowledge that already exists. Don't waste your time like searching every state law and all that, right? Just don't do that. Leverage what's already out there. The
Okay.
second thing
Go
is
ahead.
part of your incident response. So you should have an incident response plan. You should have an incident response team. The breach notifications need to be baked into that process. And what does that mean? First of all, somebody has to declare an incident. You have to determine it's privacy related or potentially privacy related, which means data is involved. And then you have to go through the internal process of who makes the determination and who actually does the breach notification and who you send it to. This is one of the big things. I've seen tables after table that says, okay, this, that, and the other thing, we're going to send a notification to the following states. Great. And I love asking the question, how do you get it to them? It's like, what do you mean? In your plan, you don't talk about email address, who's the point of contact, do you mail it, right? What's the requirement? Also, is there obligations to like your insurance company? Right? So map this stuff out in your incident response plan. Spend time with your privacy folks, spend time with legal, spend time with compliance, and that'll solve you a lot of headaches and tabletop it, right? Do your
Mhm.
dry runs.
Thanks, Alex. And we'll now move on to some of the penalties and fines that have been given. Julian, would you like to speak a little bit about penalties and fines?
Yeah, sure. Alex forgot to mention that data breaches always occur on Friday afternoons, by the way. It's always Friday afternoon, like
Or
95%.
holidays. Or holidays.
Holidays, right? Yeah. Always like the day before Christmas, something like that. And data breaches are the most important thing when we talk about penalties and fines, of course. So penalties and fines are scary. As you can see, 4% of annual global revenue or 20 million, depending on which is higher. For myself, I know which number is higher, but for like a big company, 4% of the revenue is a lot of money, as you can imagine. Um, how much of a fine you have to pay really depends on the circumstances of each individual case. So, for example, did you act intentionally, negligently? Which degree of negligence? Were there any actual damages? Did you do any harm to anyone? Did you try to mitigate that harm? Was it the first time? Was it the second time? Was it like the 50th time? Or yeah, it really depends on your business model too. So if you're a social media company that has like a daily data breach and basically handles fines like a tax, which companies actually do, that's probably more dangerous for you. I think sensitivity of data also plays a role, a certain role, but I think the amount of data inside the company currently is more important. You could say big company, big data, big risk, big fine. That's basically how it currently works. However, we recently saw an uptick in enforcement action against smaller companies, especially in Germany, in Spain, and in like Western Europe. You have like enforcement action against smaller companies, particularly in the areas of healthcare, health data, and AI. I think we haven't talked a lot about AI today, surprisingly. Always talk all the time about AI when it comes to data privacy these days. But AI, of course, will change that landscape too, because AI basically enables smaller companies to handle a lot of personal data, personal information. And as mentioned before, if you have a lot of personal information, that makes it more likely that you will face a fine of 4%, 20 million, something you don't want to pay in any case. So that being said, I think most regulators would ask you what you think you're doing before they actually enforce in that way. So typically you have to resolve the issue you face before something happens. That's no promise. It could be that they will fine you like immediately, but typically as a small mid-sized company, you will get your opportunity to rectify your errors, unless there's a data breach. Data breaches are bad and you should definitely avoid them.
All right. And Alex, do you think that these huge, heavy fines and penalties have had an effect on making companies more proactive?
Oh, absolutely. Absolutely. Unfortunately, a lot of the ones that seem to react because of the fines are the companies that have been fined, right? So it's somewhat of a question of how much impact does it have on the folks that have not been impacted yet. Part of the reason, well, we could talk about why, but in general, I find there's organizations do this because it's the right thing to do and it makes good business. You have organizations all the way on the other end that try to do the absolute bare minimum they can and hope nothing happens. And then the majority are somewhere in between. So, how much of an impact it has, I'm sure it definitely has an impact. Where I've seen the greatest impact are the folks that weren't acting correctly or they thought they were and they had some soft spots, and then they they take it more seriously.
Mhm.
So it has who it impacts the most. I think is a coin toss.
And unfortunately, we've come to the close of our program. We would love to have extended this to discuss other topics. Thank you so much to our entire panelists, and thank you to the audience.
Yeah, thank you.
Thanks, everyone.
Thanks, everyone.